Hello, I'm Robert Bateman, and this is the Privacy Corner, where I talk you through my top 3 picks for privacy developments each week. And thank you, as always, to Privado AI for supporting the show. So this week, we've got a really good bread and butter GDPR case from the UK courts, first one for quite some time. Noyb is going after Google Chrome's privacy sandbox, and New York has enacted a really interesting child data protection law. So first up, this UK court case. This is about Mr. Cameron, a landscape gardener, and Mr. Harrison, his client, who is a property investor of some sort. And Cameron did a job for Harrison with a rather huge bill attached. And when it came to settle the invoice, they had a rather unpleasant exchange on the phone. Mr. Cameron recorded the conversation, two conversations, and shared them with some friends, family, and employees, who then further shared the recordings with other people. Harrison put in 2 subject access requests, one to Cameron as a person, a natural person, and one to Cameron's business, asking to know who got the recordings, who are the recipients of my personal data. Cameron refused, and so it's gone to court. So 4 questions for the court. Firstly, does the purely personal or household exemption apply here? Now, the court, to answer that, looked at the classic CJU case, Jehovah's Witnesses, and said the emphasis here is on purely personal or household. This processing was at least partly to do with Cameron's work, and so was not purely personal or household, and the exemption did not apply. Second question was Cameron, as a natural person who received a subject access request from Harrison, a controller? And the court decided that he was not. It was only his business that was the controller here. And they drew upon various English law cases and also the EDPB guidelines on the concepts of a controller or processor under the GDPR from 2020. So, second question, no. Cameron, as a natural person, was not the controller. He might be in other circumstances, but not in this case. Third question, was Harrison entitled to know who received copies of the phone calls from Cameron? Now, as you'll know, under Article 15(1)(c) of the GDPR, data subjects are entitled to know the recipients or categories of recipients of their personal data. So which one is it? Well, the CJEU looked at this last year or the year before in the Austria Post case, one of the Austria Post cases. And the CJEU said that controllers have to tell data subjects the specific recipients of their personal data and can only say the categories of recipients if it's impossible to say who the specific recipients were. So the English court here agreed with that and said that Cameron, in theory, Harrison was entitled to know the identities of the recipients of these call recordings. However, Cameron cited Article 15(4) of the GDPR, which says that when you are processing subject access requests, you have to consider whether you're going to have an adverse effect on the rights and freedoms of third parties. In this case, the people to whom he sent recordings. So he thought, probably justifiably, given the nature of the phone calls, that these people might be in some sort of danger of being threatened themselves if he revealed their names to Mr. Harrison. And the court agreed. It said that he made the right call there. This would have affected their rights and freedoms. And so in this case, Harrison was not actually entitled to the identities of the recipients of his personal data. So, interesting thing for me about this case is that it really relies quite heavily on CJEU and EU guidance. There's a lot of English and Welsh law in there, of course, and UK law, but not entirely. And in the UK, we were told during the referendum, Brexit means Brexit, which is a bit of a vague sort of truism, but I suppose was intended to mean we really are leaving the EU. And indeed we did. CJEU judgments are no longer binding on the UK courts. However, as the judge says, he may have regard to them. the judge can take them into account when interpreting UK law. So takeaway for me is UK data protection professionals need to keep an eye on Luxembourg and Brussels and Strasbourg and the EU in general, because it can still have implications even if they're only dealing with UK-based data subjects. Next up, Noyb is back. Last week we looked at their complaints against Meta and Microsoft, and now they're going after another big tech company, Google. And this is all about the privacy sandbox. It was only a matter of time until Noyb took issue with this initiative, I think. So privacy sandbox, very, very quick primer. It's a set of initiatives, one of which is to replace third-party cookies with topics. And topics, instead of sharing personal data about people to various vendors and supply side and demand side and so on, it does the processing in the browser, as it were, on the person's device, and assigns them topics of interest based on their browsing history. So this is probably an improvement from third-party cookies for privacy's sake. There are competition issues that Google's dealing with, but from a privacy perspective, even Noyb concedes that it may be true that this is less invasive than third-party tracking systems. But Google is promoting it as a privacy feature, and Noyb disagrees with that. Max Schrems says, if you merely steal less money from people than another thief, you can't call yourself a wealth protection agent. That is a classic Schremsism. He really likes these kind of analogies. So some users of Chrome will have got this pop-up you will see on the screen now if you're watching, saying, turn on an ad privacy feature, describing topics as a way to give you more control over the ads you see and protect your privacy. And the options are turn it on or no thanks. There's a second layer to this pop-up that describes some other features of topics, including site-suggested ads, which Noyb says is basically just retargeting, and ad measurement, so analytics type stuff. And the options there are got it or settings. Now, Noyb is very unhappy about the language Chrome uses here, and also the choices they give users. Things like protect, limit, privacy features are normally associated, Noyb says, with cookie blockers, not topics, which is actually an ad targeting feature. And the second pop-up displayed a privacy shield as the kind of icon, and Noyb said a better icon would have been a camera spying on the browser content. So the allegation here is that the phrase turn it on in the consent flow is ambiguous. It should be agree, consent, or accept, or something like that. And got it on the second layer is a kind of dark pattern too, because it actually it invites the user to kind of skip opting out of certain additional processing that Noyb says Google should be getting consent for. So the allegations are under Article 5.1a, fairness and transparency, and Article 6.1a, consent as a legal basis. And here we have another example of Noyb trying to get around the one-stop shop. They keep doing this with various different approaches. In this case, they say, as the tracking occurs on the level of the data subject's browser, there's no cross-border element to the processing, so the one-stop shop should not apply. They are trying to avoid the Irish DPC here because it slows things down. They don't like the Irish DPC's decision-making. It's a very adversarial relationship between Noyb and the DPC. So they're trying various different ways to get out of having to deal with the Irish regulator, and this is the latest one. Probably a fair point. I expect there is some cross-border processing, though, perhaps in this project, but we'll see if it works. Lastly, New York has passed the New York Child Data Protection Act, NYCDPA, and the governor signed this bill this week, so it will be law and it will come into force in a year. And it's a very interesting piece of legislation, quite short. It applies to, well, it protects a certain class of person, a covered user, who it's kind of does this backwards application thing. Basically, if you have actual knowledge that a child is using your website under 18, or your website is primarily directed to minors under 18, website or app or online service, then you're covered by this bill. There's no revenue threshold or anything like that. And the one kind of rule here is that you have to apply privacy protection by default. And that means not processing the personal data of a covered user, i.e. a minor, unless the covered user is 12 or under and you're compliant with COPPA, or they are 13 or older, and the processing is strictly necessary for one of the law's activities, predetermined types of processing that you can do, or you get informed consent from the minor themselves, not their parents. So this is another US law that basically has a blanket prohibition on the processing of personal data unless you're doing it for one of a set of prescribed reasons. And the reasons in this case are quite narrow. There's only 9. Providing a specific product or service requested by the user, internal business operations, not advertising, technical errors, malicious, fraudulent, or illegal activity, protecting against those things, that is, not committing them yourself, legal claims, complying with the law, complying with an inquiry or investigation, preventing security incidents, or protecting someone's vital interests. That's it. So there's really not a lot of wriggle room there unless you get consent. And the consent standards, these are getting more and more radical in the US. They kind of started out with the basic GDPR definition, just kept building it, and saying what it is and isn't. Now we have this requirement to clearly present an option to refuse to provide consent as the most prominent option. So it's kind of like a reverse dark pattern here. You have to make the option to refuse more prominent than the option to accept. So we've seen this kind of very strict data minimization, purpose limitation, very strong consent standards in Maryland last month. The American Privacy Rights Act has this kind of model too. Washington My Health, My Data Act. If the US adopts this kind of framework as its standard for privacy laws, that will be a huge shift in the privacy landscape in the US. They've gone from virtually nothing on a cross-sectoral level to a really quite strict approach of telling businesses they can't do anything apart from this list of stuff unless you get this extremely strong level of consent. So keep an eye on this one. And if you offer child-directed services or have actual knowledge that children are using your services in New York, then definitely want to pay attention to. So that's all from me this week. I put a note here to remind you to subscribe to the Privacy Corner newsletter. So I will link that in the comments on LinkedIn. And thanks again to Bravado AI, and I'll see you next week.